It was a little while ago that I was watching the submissions to the Parliament's Committee on Land Reform by a number of individuals. We've obviously had submissions from across the political spectrum, left, right, from people from civil society organizations, and from all over. And I think at least one thing that can be commended is the people who have been able to give testimony, one of which was a certain rather well-known lawyer in our circles from the Johannesburg Bar who was discussing what I thought was a very interesting angle. So today I'd like to welcome on to the Rational Standard podcast, Mark Oppenheimer. Mark, how are things on your side? Welcome.
Excellent. Thanks for having me on the show.
No problem. Mark, would you mind just introducing yourself to the listeners a bit?
Sure. As you say, I'm an advocate at the Johannesburg Bar. I was acting on behalf of the Johannesburg Attorneys Association. So we put forward a submission to Parliament to look at whether or not the Constitution ought to be amended to allow for expropriation without compensation. In my practice, I deal with a fair amount of property rights-related issues, in addition to other sort of constitutional matters relating to free speech and hate speech.
Do you mind if I ask briefly, I know you've represented some very, very interesting people. Could you mind just mentioning a few names of people, organizations who you've represented?
Sure. I do a fair amount of work for AfriForum. So we've been involved in some litigation around free speech and hate speech. I recently acted for the South African Human Rights Commission against Valapi Kumalo. Mr. Kumalo was a member of the ANC and who made a statement that became quite notorious, saying that we should do to white people what Hitler did to the Jews. They deserve to be hacked to death and burnt alive and their children turned into garden fertilizer. And so the Human Rights Commission sought an order that his words be declared hate speech, which was ultimately granted. I also do a lot of work for property owning associations who are often exploited by municipalities, and so I help them in that regard.
All right. Well, one of the things I was interested to talk to you about was international law. If anybody watches your submission to Parliament, you talk about that aspect to a fair degree. And I thought this was quite interesting because I hadn't really heard anybody else mention this aspect of it. So, let's go right from the very start. I think we're all very familiar with certain international organizations. But if you were to describe what exactly international law is, could you give a description of that? And I also want to ask, in addition to that, what organizations that make international law are binding to South Africa? Or is South Africa bound to, rather?
Yes, so our Constitution makes it explicit that international law must be considered when any court or tribunal is interpreting our law. We also say that we are bound by customary international law. So international law is a complicated thing in that some of it is dealt with by a treaty. So in other words, people sign up to be bound by certain treaties. And some of it basically passes into common use and then becomes part of customary international law. So one of the arguments that was raised by the JAA was to say that there are international law treaties that look at this question around expropriation by states. There's a general view that states do have that power, but that it is always accompanied by an obligation to pay compensation, and that compensation must be adequate compensation. And then each state is given some latitude to determine what counts as adequate. So, the idea is that states are often going to be put in a position where they need to acquire things that are privately owned. So if you think about big infrastructure projects like roads, or maybe setting up a school or a hospital in a certain area, often you're going to need to acquire private land. And so the view is that that's permissible under our Constitution and permissible under international law, but you must pay compensation. Now, in our Constitution in its current form, we say that there are a number of factors that must be taken into account when paying compensation. We say it must be just and equitable, and that must make reference to, first of all, market value. So you determine, what is this thing worth? And you determine that in isolation from the fact that the state is trying to expropriate. So, for example, you might think that an expropriation scheme would artificially drive up the price of property. In other words, people say, you need my property because you've got to build this road, so I'm going to ask 3 times the ordinary market price. And our courts say, no, you can't do that. It's a thing called the Pont-Accord principle. When you determine market value, you determine it ordinarily. You can then adjust up or down based on other factors, one of which is the history of acquisition. Otherwise, was there a loan from the state? Had you received a state subsidy? What is the use of the land going to be? So all of these factors will then determine what amount you must pay in compensation, and that must be just and equitable. And so the argument is that if you removed a requirement of compensation at all, if you had a blanket expropriation of compensation of land in all instances, that would be a breach of international law. And because it is such a widely held principle, it's part of customary international law. And so South Africa will be flouting that if we remove that from our constitution.
So that is the other thing which I wanted to ask on is obviously in domestic law, for lack of a better word, supposing a citizen breaks the law, the government has the authority to prosecute that citizen, and we have appropriate punishments which are laid out, such as fines, jail time, and so on and so forth. But when it comes to international law, seeing as there are various bodies which make different kinds of international law, some by treaties, other may be, for example, by, I don't know, perhaps signatories to a charter from the United Nations or something like that, what kind of punishments can a state which flouts international law expect to receive?
Well, you could wind up being taken to a tribunal where someone whose property has been confiscated by the state then lays a financial claim. So against South Africa, saying, I have an international law right for compensation. You took my land without any compensation. It's a breach of international law, and I want payment. As far as I understand, something like this happened in Zimbabwe. So Zimbabwe was engaged in large-scale confiscation of land, and some of those people fought Zimbabwe in international forums and were successful. And Zim was required to pay enormous amounts in compensation, and I think under the new regime, undertaken to do that. Interestingly enough, from what I gather, Zim is now trying to rectify the wrongs of their land confiscation process in the 90s and 2000s, and are trying to pay compensation to the farmers whose land was seized. So Zim has sort of gone through this turbulent cycle of stealing people's land, recognizing that it's wrong, trying to make amends. And South Africa appears to be a few steps behind because we're about to start the confiscation process.
Now, on a slightly different question, you obviously made your argument that according to international law, we would be flouting certain charters or certain laws, and for that reason, it would be a bad idea. I'm interested to ask. This is a bit of on a different topic, but is having international law binding on an individual country really a good idea? And there's two potential problems I could see with that. The one is that people who want to argue that sovereignty is really important. Personally, my own political beliefs, I don't really subscribe to that view, but I think many will say that it's important for a nation to be able to do things according to its own laws and not be bound by some extranational body. This is sort of where Euroscepticism comes up in Europe, and there are even some people who want certain countries to pull out of the United Nations. So that's the one thing. The other thing is that have there ever been times throughout history where there have been widely regarded treaties or international laws of some kind which have been bad? I mean, it's patently obvious that individual states have had and still have laws which are, morally repugnant. Apartheid is the most obvious example in South Africa. But internationally, have there been examples of things which are of the same caliber?
Interesting question. So I think you're right. The first claim is that you want to protect state sovereignty. That state should have some level of freedom in terms of deciding what rules they will use to govern. And so that sort of set of customary international law is a kind of set of principles which all reasonable states will agree to. So, for example, you have crimes against humanity. The idea that if you perpetrate a genocide against the people, that is a breach of customary international law, regardless of whether you have any domestic laws prohibiting genocide. Now, I think it's pretty hard to argue that states should have the freedom to annihilate groups inside of their borders. That if they happen to have disdain for Armenians or Jews or whatever minority group you can think of, that they should be free to exterminate those people, and that they're not bound by any kind of international sanctions. So it seems clear to me that there ought to be restrictions on state sovereignty. The question, of course, is how you deal with that infraction. And sometimes it's through other states intervening in your state, sending in, peacekeeping troops, or applying international law sanctions. So often the ways of resolving them are political in nature. With regards to bad laws, I can't think of anything offhand from a customary law international basis that's bad. And maybe part of that is because, in other words, there's a minimum consensus requirement. This idea of, well, it must be widely spread. There must be a general view that these are good ideas. And they tend to be things like, don't confiscate land without payment, or don't engage in genocide. And with regards to particular treaties, well, there might be things that people have signed up to that are bad for their citizens or a bad idea. But if they've done it freely, they've signed up for that treaty.
Let's move on to the specifics of expropriation without compensation. I'm interested to put to you a scenario which I've always had in my mind, but I've yet to have answered. So here's the scenario, and if you could give me a legal answer to what would be done in a situation like this, I would be interested to hear it. Obviously, in South Africa, we are living hundreds and hundreds of years after conquests in South Africa, which would have displaced people of their land. Now, seeing as it's hundreds and hundreds of years afterwards, land which, let's take an example, you have a plot of land which was stolen in the 1600s. The guy who stole it sold it to someone, who sold it to someone, who sold it to someone, and every transaction after that point has been legitimate. And so it's safe to say that the current owners have not participated in any sort of theft. But regardless, this land is indeed stolen property. What could be done in a situation like that? Now, obviously, the problem is that the current owner of the land has purchased it legitimately in good faith. He's not broken any laws. But somebody else has been wronged, and it's really impossible to try to seek compensation from the original person who stole property. So what is to be done in a situation like that?
Okay, so there's a philosopher, Jeremy Waldron, who looks at these sort of cases of intergenerational injustice. And he makes a quite compelling moral argument for why you might want a limitation in terms of time. So the example you've given, we're looking at 350-year history. And he says, well, what we're supposed to be engaged in is some sort of but-for test. In other words, if the land wasn't taken from this person in an illegitimate manner, what would have happened? And he says, let's say we take it to today. In other words, I come and I steal your car. Okay. You have a pretty good reason to say, well, I should return the car. I should receive no compensation whatsoever when the car is returned to you. I'm the direct thief. Okay. And when we do the but-for, we can say, well, we've now managed to resolve the injustice perfectly because of the short delay in time. When you're looking at 350 years, the difficulty we have is trying to determine, well, what would have happened to that land otherwise? Would it have gone down to that descendant 350 years down the line? Well, we don't know. That original landowner might have himself sold it. He might have gambled it away. He might have lost it due to weather conditions. All sorts of intervening factors that have nothing to do with the theft may have meant that land never wound up in the estate of the descendant. And so he thinks the further back in time you go, you have more moral reason to say that you ought not to have compensation in those cases because there's so much noise in history. So he thinks that you should have a kind of cap-off within living memory. And that's kind of what we do at the moment in our Constitution. So we have a cut-off period of 1913, so just over 100 years. It's 1913 because of the 1913 Land Act. And the idea is that if you were dispossessed after that, well, then you can have a claim for compensation or for the restoration of your land. Now, the second part of your question is regards to, well, what do you do about these innocent parties who happen to be in possession? So we can look at what other countries have done abroad. So, for example, in Germany, they've taken the view that if you're a Nazi and you stole Jewish property, it should be restored to the descendants, and you should receive no compensation whatsoever because you're a direct thief. Now, that seems just to me. There's no good reason to compensate a thief under circumstances when they have no legitimate claim at all to the property. But what the Germans have done is to recognize that often what you have are these multiple transfers and that the person who's in possession of the item does so in good faith and did nothing wrong. They had no knowledge of the fact that the property was stolen. And in that case, the idea is that what you try and do is restore the property to the rightful claimant, and then you compensate the person who held the property, and that the state does that. So what you do is that you distribute the loss. In other words, all German citizens are contributing their taxes towards a fund, which is then used for compensating those that are innocent possessors of property.
You see, I quite like, personally, my own opinion is I quite like that system in the South African context, because if we go back to the 1913 Native Land Act, that is obviously an act which is enforced by the government of South Africa, and therefore I think it's only right that the government is the one who should be liable to compensate in cases where the government is the one who deprived people of property. But anyway, that's just a more of a personal opinion of mine. Moving on to a slightly different topic, the rule of law is often something spoken about, and I think it's a term which is severely misunderstood. I often see the mayor of Johannesburg using it when I think he rather means law and order. Now, I know this is a rather complicated concept, but could you briefly explain what the rule of law is, and then we can perhaps talk about that in terms of the current proposal to amend the Constitution and the sort of ill effects that would have according to the rule of law?
Sure. Okay, so first of all, we must recognize that our Constitution enshrines the rule of law in Section 1, and we have different thresholds for changing the Constitution. So, for example, if you want to change something in the Bill of Rights, you need 2/3 to do that. If you want to change anything in Section 1, it requires 75%. So there's a view that's being developed partly by Mark van Staden at Rational Standard, which is that the rule of law necessarily entails the protection of life, liberty, and property. That if you change the Constitution to remove property rights, you would necessarily be interfering with the rule of law. Okay, so the debate is as to whether the rule of law actually builds in any substance, or whether it is more procedural in nature. So there's a famous paper by Lon Fuller, where he looks at requirements for things to be a law. Now, there's a view espoused by natural lawyers. Natural lawyers say basically people have a whole bunch of natural rights, either God-given or due to the nature of their humanity, and laws must be in accordance with those natural rights. So you might think you've got a natural right to life, possibly a right to property, and if you have laws that infringe on those things, it's a breach of your natural rights. Positivists don't take that view. Positivists say the way that you work out what the law is that you look at the sources of the law. So you look in your legislation, you look in your case law, you ask, were these things promulgated through the correct process? In other words, did the judge have the authority to produce this law? Did Parliament have the authority? And then you say, well, these are the laws that we have. Now, the positivists can say these laws, some of these laws are good and some of these laws are bad. They can draw a distinction between immoral laws and moral laws. The natural lawyer can't. The natural lawyer just says these things aren't law, which looks strange when it's, if you look at, let's say, unjust laws used during apartheid, the natural lawyer wants to say these aren't laws. The positivist says they are laws, they're being enforced, they're being used to put people in prison, they clearly seem to be applied by the state, they're just evil. So Fuller then says, okay, well, there must be, if we've set aside this content question, there must be other things that we can use to determine whether something counts as a law. And he has these kind of logical sets. So, for example, he says the law can't be contradictory. In other words, it can't require you to do something and not do the negative of it. He says the law must be known. You can't, he has this, in his essay, he talks about King Rex, who engages in a whole bunch of legislative actions, none of which results in any laws. So Rex writes down a series of laws and never tells anyone about it. He produces laws that say that are at odds with each other. Now, the question is whether, as I say, depending on what account of law you have, is the rule of law going to be useful in determining or not whether you can remove property rights? I think it's an open-ended question. I think it's worth pursuing that avenue of attack. There are a couple of other similar avenues. So in India, for example, their constitutional court takes a view called the basic structure doctrine. So they imply that behind the written constitution is another constitution. And there are certain things that must be in your written and they come up with a set of principles. And they say that you cannot change the constitution if you would remove those principles. If you look at the substance of some of those principles, it's not clear that everyone would agree to them. For example, they say a welfare state is one of those things that must be in their constitution. I think one of the judges says that socialism is one of those values that must be there. It's not clear that everyone would agree to that. There is another line of attack that I think is well worth exploring, and I haven't seen much writing on it at all. It's another clause in the Bill of Rights, which is Section 36. So Section 36 is the limitations clause. And basically what it says is as follows. It says, the rights in the Bill of Rights may only be limited in terms of a law of general application to the extent the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom, and then it looks at 5 other factors. Now, to change the Constitution, you would have to produce a bill. Now, that bill would be a law of general application. Let's say it said something like, all land is subject to expropriation without compensation. It would be a law of general application. But then it would have to pass this further threshold, which is it reasonable and justifiable given these other foundational values of dignity, equality, and freedom? And it may fail right there. So there's an argument that, first of all, we must recognize the Bill of Rights has never been changed in South Africa's history. The constitutional text has been changed 17 times, but for quite minor technical things like provincial boundaries or whether we should have floor crossing or not. But nothing substantive with regards to our Bill of Rights. And so there may be an argument that Section 36 provides a bulwark against infringing on the Bill of Rights, and that if they can't justify those infringements in terms of Section 36, then it must fail.
I like that third line of attack very much, and I've heard people talk about it. Certainly one politician who has mentioned this sort of line of thought is Mosiuoa Lekota. He always says that in order to understand the Constitution, you have to start reading at Section 1. Do you mind if I quickly ask, I know you mentioned this in the third line of attack, but does the Constitution have a sort of structure to it in that certain foundational principles of the Constitution are the antecedents to other amendments in it? This is, for example, if you were to amend something which comes after the Bill of Rights, which would contradict the Bill of Rights, I suppose that would be a contradiction in and of itself. But would an amendment like that be struck down legally?
Well, as I say, so I'm of the view that if there is a move to change the Constitution, to remove property rights, that it's likely to be subject to some sort of court challenge. And I think it's important that people act strategically and that a full range of different arguments are put before the court. So the 3 that I've discussed now, because we're dealing with a very novel situation where our Bill of Rights has never been changed, our courts haven't had to consider these kind of foundational questions. And, I think the more radical line is this idea that there's some sort of hidden constitution behind our Constitution. At one point, this was true. So when the Constitution was, we had an interim Constitution, then we had a final Constitution, and there was a process of certification by the Constitutional Court. And there were a set of principles which were written in the abstract, and the question was that the Constitution had to abide by those principles. But once the Constitution came into being, once it crystallized, the idea is that those principles then lost any power that they may have once had. So I think it's unlikely that our Constitutional Court would try and import extra principles. It's going to look at the document itself to determine whether you can have these infringements. And so that's why rule of law is going to be one, and you'd have to cash out exactly what rule of law means. And if there's an argument that it necessarily implies the protection of property, well, that's going to be a good argument. The other one that I think may be more fruitful, as I say, is the Section 36 line, because here we would be dealing with legislation which would be limiting the Bill of Rights, namely Section 25, and it's got to meet these other thresholds. And so when we combine that with the idea that you've got a customary international law requirement of paying adequate compensation, if that's one of those things that's done in democratic societies, well, then abolishing that is not going to seem reasonable and justifiable in our democratic society.
Since 1994 and, since we established our constitutional court in a democratic South Africa, I'm unaware of exactly what date the constitutional court came into being as it is, but I've seen numerous complaints from legal scholars who are Facebook friends of mine. I know Martin has complained about the way in which the constitutional court has been shifting ideologically. Now, as you said, there's likely to be a legal challenge. I think so long as people like AfriForum and the Institute of Race Relations remain around, there will certainly be a legal challenge in some way or another. It seems to me people like AfriForum often like taking the procedural line, which I think is a good way of attacking this. But the last thing I want to ask is, based on the sort of ideological shifting of the constitutional court, do you think that there's a chance that, even if we have a really, really strong argument, that they might take the view that in order to have some sort of cosmic justice on this issue, that it may go through? That's a bit of a vague question, but this is the sort of thing which I've been hearing from legal scholars in South Africa. Very often, the interpretation of the constitutional court takes more into account what they consider to be just, and then they use that to interpret to give decisions in cases which may run contrary to the statutes themselves, but because they fulfill the ends, they are seen as being legitimate. I hope that makes sense. I'm not a lawyer myself.
Well, I have a sense of where you're going. So one of the examples we can look at is this case of Agri-SA. So it's a case authored by Chief Justice Mogoeng. And the issue there was whether the state has the power to become custodian of all mineral rights in the country. They passed legislation which would have allowed them to achieve the status of custodianship. The idea is custodianship is different from ownership, and would then not require any obligation to pay compensation, because they would not be taking property to become owners of it, and they would not be redistributing it. They would be acting as custodian for all citizens. And there was a concern that if you could have this custodianship for mineral rights, that it could be applied to all property rights. And that comes out in Judge Froneman's dissent. But if you look at the language of the judgment, what Mogoeng does is he sort of creates an exception for mineral rights. So he says, these things have a very particular history in South Africa. He thinks that, minerals have a special status, that they're sort of a part of the earth, that we've had a history of exploitation of mine workers and of minerals in South Africa before. And so he kind of creates this little sub-caveat, and he thinks that it's justifiable for the state to engage in it, but then says, these things must be determined on a case-by-case basis, and thinks that it wouldn't apply to all sorts of other property. Now, a couple of years later, the Department of Trade and Industry tried to produce some legislation called the Promotion and Protection of Investment Bill, where they sought to apply this custodianship principle to all property, to basically your investments, your car, your house. And when it was pointed out to them that actually Agri-SA was much more limited in scope than they had thought, they withdrew those portions of the legislation. So the difficulty, as you point out, is that the Constitutional Court is the highest court in the land, that really it's bound by the text of the Constitution, but it has a fair amount of latitude. It's not directly bound by its own judgments. It could decide that prior iterations of the court had got it wrong, and then it's going to rectify that. So there's always going to be some uncertainty about what that court will do. I think it's going to depend on what view that they take. I asked this question to Mogoeng recently. He was giving a talk at Gibbs, and obviously he's in a position where it's difficult for him to answer what he would decide. And I think if he did answer what he would decide, he'd probably have to recuse himself in a further case. But his line was basically, he hoped that the parties could get together and reach some sort of negotiated settlement on this front, which implies that, in other words, there is some need for land reform. You have to undo the injustices of the past, but you also don't want to create further injustices by wholesale stealing land from innocent citizens. Now, as I mentioned in Section 36 to you earlier, that test kind of requires you to look at a number of factors. And one of them is, are there less restrictive means to achieve the purpose that you want? Now, the purpose here is going to be land reform or rectifying past injustices. Now, in my submission, we looked at some of the data around this. One of which is that between 1995 and 2014, we've engaged in a very extensive land reform process. So people could, assert claims, provide evidence, and if they proved them, they would receive compensation in the form of money or in the form of their land back. Now, during this time, 1.8 million individuals received compensation. That's an enormous number of people. The other thing that we see is that the amount of money that's been dedicated by government to the land reform process is very minuscule. In the last budget, it was 0.3% of the budget. So if you're faced with the choice of eroding property rights and sending a signal to the international community that this is not a place to invest because we may seize your land without any compensation, or saying, well, let's use some of our tax revenue to increase the budget for acquiring land and redistributing it, well, the latter seems like the less restrictive means. It seems like an option that's not going to destroy our economy, endanger food security or render, millions of people unemployed. And so that's the kind of thing that the Constitutional Court could look into if any kind of actual change to Section 25 is put forward.
Well, I think you've spoken about some very, very interesting lines of attack which we could take. It does seem to me like we have actually quite a sturdy constitution, and there are many provisions within our constitution which people just don't realize, which may hypothetically should prevent this sort of amendment to the constitution from happening. But of course, it'll be up to the highest court in the land, in all likelihood, to see whether or not that happens. I think if this does go through, we can obviously expect a legal challenge to it, and it seems to me like it'll likely go up all the way to the Constitutional Court. It is, after all, a constitutional issue. But this was a very interesting podcast. Thank you very much. You certainly educated me a lot, and it was short but sharp. So, Mark Oppenheimer, thanks very much. If people want to find you on social media, or would you rather prefer to keep it more private, where can they follow you? Facebook, Twitter, or do you keep a low profile there?
I've sent 3 tweets in my life.
All right, that's fine.
I'm more and more skeptical of social media. But if people want to read up about the kind of work that I do, so if you look on bridgeadvocates.coza, you'll see my profile is up there, and there's a list of articles that I've written, interviews that I've done, television broadcasts, and it's also a link to a podcast I did with Gwen and Gwenya called Freedom Versus. And one of those episodes looks at this question of land reform. So that's probably the best way of getting in touch.
Cool. Well, thank you very much for coming onto the Rational Standard podcast. You certainly taught me a lot, and I think this will be a very interesting episode. Just a reminder, subscribe to the Rational Standard podcast on iTunes. You can listen to us on Peeper. You can follow the Rational Standard at Rational Stand on Twitter. Give us a like on Facebook. If you'd like to read our articles, our website is www.rationalstandard.com. Be sure also to check out our partners Being Libertarian and Think Liberty. And also, if you want to follow me on Twitter, I'm at Nick Babaya. Until next time, see ya.